Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. We've created this program to educate, inform, and help you with law matters because, as we say, the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide resources that'll help you determine whether or not you need to contact a lawyer. Perhaps you'll decide that in some cases you can handle some matters yourself. If you do need additional professional counsel, our goal, of course, is that you'll be better prepared, and so will the lawyer who you select. We're hoping, of course, to save you time, money, and to achieve the best possible results. We continue to welcome and thank our attorney from the Bazar and Associates law firm in East Providence, attorney David Bazar.
Thank you, Deb.
And we also have today with us a special guest, Larry Berren from East Providence. Also, a little bit of background as I've seen it. It says that Larry has continued to provide counsel to same-sex couples, business owners in estates, special needs, asset protection, business succession, retirement tax, and charitable planning. So that's a very fitting description for what we're going to be handling today, namely wills and estates. Most of us want to not talk about wills and estates and our demise. However, the plan is for you to go through it with the least possible grief in terms of probate, avoiding taxes, but our guest today has a few other interesting views to share with us. But let's begin with David. So, who needs a will or who might not need a will?
Well, almost every circumstance, everybody should have a will. And a will can be used for things that you don't anticipate. So you may have all your assets in joint names and think, well, there's nothing that could happen that would ever require a will, but perhaps something could happen. You die in an accident and somebody has to bring a suit in your name. Who do you want to bring that suit? The person you name in the will would be the person that could do that. So everybody needs a will.
And if someone is thinking that they've done a very good job of putting together their will and then they make a change, you say something happens. What happens when people are contesting wills, as seems to happen if someone who is a beneficiary perhaps doesn't like the outcome? What happens then, David?
Well, you have to have a will that's drafted appropriately and carefully that anticipates things of that nature so that the attorney who drafted it can make sure that that will is going to stand up to a contest in probate.
We say that we provide resources so that someone could actually do some things without a lawyer. That's terrific. And of course, online, Google it, it's easy to find some information about wills, and perhaps that's a do-it-yourself, except when you have a complex situation, right, perhaps that's not wise, lest you have a lawyer who has to get involved more deeply the next side.
As Larry is going to explain, attorneys that know what they're doing in this area aren't selling documents. You're not coming to us to buy a will or to buy a power of attorney or healthcare power of attorney. It's the advice and the information that we gather from you to help you make the right choices that you're paying for our expertise for.
Good springboard. Okay, Mr. Berren. Where do we actually depart from what that little online, give me the name, address of your home in Florida, where does that change from when someone is actually speaking to a lawyer? How does that differ?
Well, there was, you may remember, there was an old Fram oil filter commercial where the tagline was, you can pay me now or you can pay me later. So for those folks who want to draft their own will online, what they're going to get is a document, maybe 5 or 6 pages of paper. What really goes into the drafting of a will is the counseling, because so much of this is driven by family dynamics. And so, people in general are best served by meeting with an attorney. We, in our office, we have a practice of meeting initially with clients at no charge for an hour or so that they can come in and not worry that the meter is running. They get to explain what it is they want to accomplish, what their goals are for the process. And then typically what we do is once we've heard them out and we know what it is they want to do, we'll make a recommendation to them, and at that point we'll quote them a flat fee. And typically this is the kind of legal work that can be done on a flat fee basis. So I would say in general, if you go to an attorney and when you talk about fees, they say, oh yeah, this is hourly. you probably want to ask to talk to somebody else, because it's not, it's quantifiable, if you will. It's, the attorney who has done this in the past knows how much time and effort it's involved. And again, the clients, they deserve to know what it's going to cost without worrying that the meter's running every time they pick up the phone.
What kinds of questions might you ask that certainly couldn't be listed in a checkbox in a single line on an online form or any kind of form? You do some counseling, family dynamics. Give me an example. Well,
so here's the thing. Most people, when they come in and we start talking about estate planning, they think, gee, this is death planning. I need a will. I explain, I say, death really is the easy one. The more complicated situation is you're here and you're no help anymore. And there are all sorts of things that we need your signature for, we need your input, and you're not capable of communicating. No one will take your signature. And so I'll quickly shift the focus of this to mental incapacity or cognitive decline planning. And that really, it kind of opens people's eyes, and then they, typically what I'll do, my job is to scare them, to get them to think about, what if all this befell me? What's it going to look like? How is my family going to work? Are they all going to get along? Who would be the right people to pick to make financial decisions, to make healthcare decisions? So that's what really kind of gets people excited and interested about the process.
And what happens is, as you say, scare. As attorneys, we always have to think about the worst case scenario and advise you that, well, you're planning on if everything goes well. Well, here's the worst case scenario, and this is what you need to know. One of the things Larry often tells people, and I think, do you still do this? You say there's two things that go into an estate plan, people and property. Mm-hmm. And it's not the property that's going to screw it up, it's the people. Right. So the counseling begins usually with the family and the family dynamics.
Right. And of course, you get none of that online.
And so we started to speak about a will. When does someone need a different kind of instrument, namely an estate plan?
Or a trust, as I
or
think
a trust,
you're going to.
as part of the estate, yes.
So again, let's take a situation where we've got a 26-year-old woman. She's involved in a serious relationship. She's kind of transitioning from being a daughter, a part of that nuclear family, and making her own way. And God forbid she has a stroke, she's in an accident, and now we have the boyfriend, fiance, who is trying to convince the doctors to listen to him, and you've got the mom and dad who say, "Oh no, she's our daughter," and so you've got a problem. So what I typically will suggest to the people I see who are the parents, your daughter needs healthcare documents. She needs to make a decision. Is it going to be you, or is it going to be her fiance who's going to be making decisions? So for that 26-year-old, I wouldn't talk to her about a will. She probably doesn't have anything to control, no assets. I'd say get some healthcare documents in place. That would be the most important thing. So it really depends on the circumstances. Who the person is, what their circumstances are, and give them the choice as to who they want making decisions for them, rather than just kind of throwing up their hands and letting it play out.
And what about the property? When do you need a will to cover it? When do you need to put it into a trust? What is a trust? How does that work?
Okay, so again, starting with younger people, and some people never get around to estate planning. I understand, I respect that. Some people, do it in their 20s, maybe after if they're married, have children, after they've had their children, to name guardians for the kids, and then perhaps upon retirement, that would be another phase, and then toward the end, that would be where you get a final look at things. And depending on their stage of life, they might need different documents. So, I would say the will probably isn't going to matter until 40s, 50s, because here's the thing. Most folks, if they're savers, where are they going to save? Retirement accounts. So, and retirement accounts passed by beneficiary designation. Doesn't matter what it says in the will, it's who you named as your beneficiary. So don't need to worry about that. They begin to get some equity in their house. If they're married, they probably own it jointly with the spouse. That makes sense. So again, at the first death, it'll automatically go to the spouse. So it would be a good idea maybe in the 40s to have a will, but you're probably not going to need it if you're in a solid, married, committed relationship. Trusts, to answer your question, usually in the last two phases, when they've retired and now they've accumulated some assets outside of retirement accounts. The reason to have a trust is to several reasons. One is to avoid the red tape associated with probate, which if you have a will, you're going to go through probate with those assets. Second would be to make sure that what you're leaving your children as an inheritance is protected from people who might be trying to take it away from them. A soon-to-be ex-son or daughter-in-law, bad driving, bad luck. Creditors of all kinds. And then, of course, if you have a lot of wealth, you might create an irrevocable trust, which would be a way to get assets out of your name to protect it from estate taxes. But you don't want your beneficiaries getting the money all at once. You want it protected for them. So that might be some instances.
So what's the difference, David, between an irrevocable trust that Larry just spoke about and a revocable trust?
So just what it says, a revocable trust we use to do a lot of what Larry's talking about, but to leave the settlor, the person who creates the trust, the options of changing things in the trust as it goes along. An irrevocable trust takes that property from the settlor's control and puts it into the trust under the control of somebody else. And if you don't give up complete control, it doesn't do the things that usually you intended to do, which in the case that Larry was talking about, to remove it from your estate for tax purposes, so that when you pass your wealth on to somebody else, in Rhode Island, there's a tax, where does it come in now, Larry? About $1.5 million?
1.5, a little over that.
So if you're over that and it's in your estate, you're going to pay tax on federally about $5 million, or right now?
5.5.
5.5.
Mm-hmm.
So depending on what you're trying to protect against, if it's to avoid estate taxes, you need to give up control, or else it'll be deemed to still be within your estate.
And so when someone starts to plan for their eventuality, a will might be a place to start, and then over years you might consider what would happen next, namely a trust. Maybe it's irrevocable, maybe it's revocable as their life changes, divorces, and whatever the situation is may evolve. Sure. And so how often do you consider that things should be reevaluated when you're not talking about the fact that someone was just divorced or whatever? That would be obviously a trigger, but in general cases, 5 years, 10 years?
I think it's circumstantial. So again, different time frames when you would start your estate planning. But the times that I mentioned, certainly if you're open to the process, you have kids, you want to be able to name substitute parents if you and your spouse, God forbid, something crazy were to happen. The next time, again, would be maybe when you're an empty nester. And now, gee whiz, we've paid for our kids' education and we're starting to accumulate some assets. What do we want to do with it? Next phase would be upon retirement. Perhaps you lose a parent. Perhaps you suffer some kind of physical significant event. Those are things that are going to get you thinking about it. And every situation is tailored to the particular person. And of course, and I don't want to leave this out either. There are a lot of people who think, gee whiz, I want to leave this world a better place than I found it. And so they want to designate some part of what they've been able to save to a charity.
When that happens, Larry, do you generally find that someone in your position would suggest that the beneficiary, say it's an organization of some sort or a school, would you suggest that that school or that future recipient be notified in advance or not? Do you even touch upon that?
Good question. I mean, if you do, you'll get invitations to lunches, which are nice.
Yeah.
Lovely.
But
other than that?
but
Does
if
it
you
matter?
want to change it, because usually those kinds
Good
of
point.
designations they're not irrevocable. You can, if you kind of lose interest in the charity, you can switch it over. One thing I do want to say too is where we see most of our clients accumulating wealth, it's in their home and it's in their retirement accounts. Retirement accounts are funny assets. They have this income tax liability attached to them. So when you take money out, it's as if you had earned it. And the net result is that once we pay estate taxes, income taxes, basically we're talking about maybe 60 cents on the dollar that ends up going to the beneficiary. And yet, if you name a charity as a beneficiary of that IRA, or a portion of it, they get 100 cents on the dollar. So if people are charitably inclined and they want to leave this world a better place, that's the best asset to use to kind of fund that vision.
Interesting.
And so I totally agree with what Larry's saying. It's usually done by a designation of beneficiary or in a trust or a will that's revocable so that you can change it. There's a higher end plan sometimes that's done where you actually make a gift, either a lead charitable trust or a remainder trust, where the institution needs to be notified because they're part of that document. And it's a different situation than Larry's describing, but it's one where there's someone who has more than enough money for themselves and their family, or they want to use it as a tool to transfer money so that you might do what's called a lead charitable trust, and correct me if I'm wrong on this, you're the expert on it, but you put money into a trust that's used by the institution at first, and then that's a remainder trust, then the remainder would pass to your beneficiaries to get it out of your estate that way. Is that?
That's a lead trust.
Lead trust,
Yep.
and get some deductions for it when you make the gift.
Right,
Yeah.
right.
When people are designated as the executor of a will or the executor of a trust, are they paid? And I understand that people like to avoid taxes, but those things are taxable too. Can you speak to, I heard something about 4 to 5% on probate and wills. How does that work? Who gets paid and how much is deducted? How does that work?
It depends on the situation and who gets named, and I do not believe that they use percentages to pay any fiduciary.
Okay.
If you name a corporate trustee, they're going to charge, and they'll probably charge an hourly rate, and it has to be approved by the probate court judge.
Right.
So that is something you need to know. If you name a trustee in a trust, there's going to be a corporate trustee, there's going to be a charge.
Sure. Yeah, and the 4%, some states allow that, but the trend is because there's gouging, an executor might say, hey, I want my 4 or 5%, and they've done no work.
Right.
So more and more probate judges are saying, no, you need to keep track of your hours and submit them, and we need to make sure that it's all reasonable.
And while we talk about a trust perhaps avoiding probate, and that's one of the reasons one would do it, is there ever really an opportunity for you to put absolutely everything in a trust? Your grandmother's ring that's yours, that's after you are gone, does that go into a trust, or is that part of a spillover will that can also be contested as a, how does that work?
Yep. So best thing is to have grandma give the ring away while she's alive, so we avoid all this. But in general, personal property, things like jewelry, it kind of flies under the radar. And so we don't, in fact, when we do living trust-centered planning, we have the client sign a document called Assignment of Personal Property, which is very much theoretical, but it says, I'm putting all of my personal property into my trust. It doesn't move, it's the same table, but now it's in my trust. And so we typically, unless it's a Van Gogh or something of real value, we just assume that it's in a trust for a living trust-centered plan.
Right.
So if you folks are capable of counseling and keeping family dynamics or keeping a lid on the heated discussions that come from, does that keep the discussion about which daughter or which sister now gets to have the dress, mom's wedding dress or such and such a ring? Do you end up taking care of that at the time of the will is read or the trust is not disposed of, but being analyzed. When do you handle that, and do you handle that?
Well, you zeroed in on the biggest problem. I mean, it's not the money. It's always, you know, mom liked you best, and you know, so I have presided over, you know, issues about that, but it's tough because you're dealing with family dynamics that are rooted way back, and you know, people are people. If you know, you do your best to facilitate some kind of a harmonious resolution, but good luck.
Yeah, a lot of times it doesn't come up until you have the death and you have to deal with them. Sometimes you know it's coming, and I have been involved in situations where I bring the family in and we talk it out beforehand.
Sure.
Sometimes it works, sometimes it doesn't, but I always think if you know there's going to be an issue, try to deal with it up front. That's part of why you're coming to us and part of what we can help you do.
And here's the other thing too, you know, parents are in a leadership role. But you get to a point where they're in their 80s and the kids now think, no, I'm the leader. And so sometimes, depending on the family dynamics, you need to sit down with the parents and say, hey, you need to assert your authority here. You know, I know
You, the lawyer, would be saying that?
Absolutely.
Sure.
Because, you know, I figure if they're not doing this online, I need to do more than provide a stack of documents. I need to give them counseling. And so yes, you know, if I anticipate that there's going to be that the kids are not behaving, you know, I'll sit down with the parents and say, you need to crack the whip on your kids. Remember, you're in charge. And there will come a point where the parents, you know, they'll just, oh, I can't, you know, and it's too bad if they give up. You hope at that point that the kids, you know, do the right thing and they take that mantle of leadership and do what they're supposed to do with it.
And the reason I like to try to address it early is so you don't have to deal with it after the parents are gone. And if it's not an irrevocable done situation, the parents have leverage. Because I've had clients who have been strong-willed parents, and they said, all right, this is what we're going to do, this is why we're doing it, and if you don't like it, I might just change my will or change my trust.
Interesting, when I brought this subject up in the beginning, I had just looked at your website, in fact, Larry, and I was very prepared today to have the discussion about, tell us how we're going to avoid taxes and the costs of probate, and that's fine. And yet I saw in a quote that was on your website something that referred to it's not just about that or not only about that, it's also about a commitment to the situation. It's an act of love, which is a very interesting thing that we generally don't see associated with attorneys' law firms. So actually, I think that you are bringing up an aspect that we haven't had an occasion to talk about before, namely the family dynamics and the leadership that's beyond who gets which piece of property.
Exactly. You know, it really is about, you know, as David said earlier, property, people. It really is all about the people. I mean, you know, as estate planners, we provide top shelf tax advice, so that's a given. But the real talent I think that David has, and maybe I do as well, is to give the family its best chance of surviving to the next generation in whole, intact. And for folks who do come in to do the estate planning, yes, they get the good tax result. Yes, they get the good probate avoidance result. But above all, it's really a commitment by that senior generation, an act of love, to make sure, as I say, that the kids have the best chance of still having Thanksgiving together, you know, into the future.
Right.
And while we speak about the portion of love on the one hand, there is that money that starts this conversation often in the first place. So how do you work with someone, in the brief amount of time that we have left, how do you work with someone to make sure that they are handling the finances and the taxable portion of an estate well? It's your attorneys. Do you bring in an accountant first? When? How do you work? How do you set that relationship up and work that through?
Typically, say the parents have a relationship with a CPA, and so I'd like to involve the CPA early on, just so that everybody gets to weigh in on how it might play out. After death, typically we do the estate tax return. Most CPAs are familiar with the income tax, less familiar with the estate tax, and so we need to have conversations back and forth. So I hope that answers the question.
Yeah.
Do you usually find?
That's
David?
how you do it. A lot of the wealthier clients may have a business, and so that presents some issues in estate planning. So you need the accountant who's been dealing with that to be involved in that. And as Larry says, most accountants don't want to fill out the complicated estate tax return that needs to be done. That's what we do, and there's some expertise involved in that.
So to get into the weeds just for a second, if someone has a trust and they have various pieces of property, and you have found or suggested that they should go into LLCs, each of these properties, and each of those has its own taxable issue or event every year, I guess, as well as when someone dies, whose lap does that fall into? Yours because you suggested it, or the accountant's on the other hand?
Well, a person dies and they have interest in LLCs. Their interest gets valued as part of the estate.
Okay, that's where that goes.
So that's where that goes. The accountant is going to be responsible for, I mean, if the property within the LLC is sold, there's inside basis, outside basis. That's really in the weeds.
Yeah. Yes.
But kind of we would work together with the accountants, straightening that out.
I think what she's asking a little bit is in creating like a family limited partnership or an LLC to hold property, family property or whatever. We'll create those documents, and we will each year do the annual reports and all of that, but the accountants would be handling whatever, if there's any income being produced in them. But generally, if it's just like real estate that's not investment property, there wouldn't be any tax, like on a residential property that's being held in a family trust or that type of thing.
Right.
Sounds right. Yeah. We did get into the weeds a little bit, but it certainly says that if there's a complex issue, and that certainly was one of the more complex and entangled ones, that it's difficult to think about just doing something like that online.
We have a lot more complex stuff we can talk about another time.
And how that actually does settle out. I think that what you're saying, though, this is certainly not a one-and-done situation when someone goes online and tries to settle their whole family's estates.
Right.
Other questions is, how often do you find right now that people are contesting wills? Is that really a very predictable and commonplace event?
I don't see that much of it.
Okay.
Yeah, it doesn't happen.
Generally speaking, the people who come in to do estate planning, and they are in the vast minority, these are people who care about their families. And so typically, you're not going to find a lot of contesting there.
Thank you. Good to know. We hope that we've addressed some issues that have crossed your mind, and we hope that we've encouraged you to take care of business and check things out a little bit, perhaps initially online. We thank you for tuning in to The Law Matters. Please continue to do so because the law matters to you.